If a defendant asks to represent himself, but has made a lot of other complaints and has delayed trial, is that a clear and unequivocal request to proceed pro se? To find out, you have to read People versus Laquan Lewis, but it's 30 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Laquan Lewis. The citation for this case is 2025 New York Slip Opinion 03011, published by the New York Court of Appeals on May 20th of 2025. The issue in this case is whether in the context of a defendant who has made several complaints and delays of the proceeding, a clear request to proceed pro se is entitled to a prompt hearing on that issue. To understand and appreciate the context of this case, what's helpful to know in terms of background is that the United States Constitution has the Sixth Amendment, which contains the right to counsel in criminal cases. And it's been implied and interpreted by many cases that the Sixth Amendment, which is the right to counsel, includes and implies a right to proceed pro se, meaning to represent yourself in a criminal case if you have to, if you want to. And in New York, we have CPL 170.10 sub 6, which is a statutory authorization that says that a judge must permit a defendant to proceed pro se without the aid of counsel if it is satisfied that he has made such a decision with knowledge of the significance thereof. So there's a requirement that the court be assured the defendant has knowingly waived his right to counsel and understands what it means to waive right to counsel. But if he has, the defendant has a right to proceed pro se, representing himself in a criminal case. And the last thing you have to know is that under those cases, there's a case called People versus McIntyre, which sets out New York's three-part test, which is the first thing is that the request be unequivocal and timely asserted. So first, the defendant has to make a timely asserted and unequivocal request to proceed pro se. At that point, step two is the judge has to conduct a searching inquiry as to whether the defendant has knowingly, intelligently, and voluntarily waived his right to counsel. And the third is that the court must be assured or must be satisfied that the defendant has not engaged in conduct which would prevent the fair and orderly exposition of the issues. This can't be a delay tactic. If the defendant satisfies all three of those elements, the defendant must be entitled to represent himself pro se in the criminal case in which he is the defendant, not to represent somebody else, but to represent himself for his own case. Okay, so what are the facts in this case? The facts are that in this case, the defendant is charged with attempted murder, robbery, assault, and obstruction of governmental administration. Basically, I think he allegedly follows someone out of a store, hits him in the head, stomps on the person repeatedly, gives him a traumatic brain injury, takes their money, ultimately is arrested for it. The defendant, he was in jail for a long time before that. The defendant filed various pro se motions, including a writ of habeas corpus, a request for dismissal of indictment. He files a lot of different motions while he's incarcerated pending his trial. And the defendant, right before jury selection on July 4th, 2018, says, I want a new lawyer. Okay. He says there's a conflict of interest between him and his lawyer. The judge rejects his claim. Okay. And says that he's not going to do it. He keeps the defense counsel on. They have a colloquy. They have a conversation, which is on the record. In that colloquy, the defendant says, I want to represent myself in this case. The judge says, you mean pro se? And the defendant says, yes, I will be going pro se at trial. I will be representing myself, acting as my own. The court says, you made no application before me. And the defendant says, I never said I wanted a trial by juries. I never told this individual I wanted a trial by jury. Ultimately, the judge says, I'll deal with that later. We'll deal with it later on. The defendant then takes a plea. He withdraws that plea. And then it goes back for trial again. And when it gets back for trial, the defense counsel comes in and says, hey, judge, I think I want to be relieved from this case. My client has threatened me. And the judge says, well, work it out, guys. And ultimately, another time, he goes on the record and says, I want to represent myself. The judge says, you're going to represent yourself? The defendant says, yes. The court says, I'll deal with that. You can hire someone if you want. I'll deal with it the day of trial. Ultimately, the defendant never raises this request again. He's tried with the lawyer the judge gave him, the 18B counsel, and he's convicted of at least one count. I think he was acquitted of many things and convicted of one thing. And he files an appeal saying, you deprived me of my right to represent myself, to proceed pro se. And ultimately, the appellate division affirms the conviction. They say that the Supreme Court here, did not violate the defendant's right to self-representation because his request to proceed pro se was made in a variety of other contexts, in the context of complaints, of dissatisfaction with counsel and were not unequivocal. So he failed to satisfy step 1 of the test. Ultimately, it goes to the Court of Appeals, and here we have a split, 4-2 split. The majority here, written by Judge Rivera, says that the defendant was deprived of his right to counsel. Why? Because he made a clear, unequivocal request to proceed pro se. Satisfied by that colloquy I mentioned. When the defendant says, I want to proceed pro se, and the judge says, you want to proceed pro se? And the defendant says, yes. According to this majority, that is a clear, unequivocal, and timely asserted request. At that point, because step 1 of McIntyre has been satisfied, the judge should have and did not go to step 2, which is that searching inquiry to confirm the defendant is knowingly, voluntarily, and intelligently waiving his right to counsel. The judge never did that, never went to step 2. And therefore, the judge deprived the defendant of his right to counsel. Case is reversed, remanded for a new trial. That's the majority. There's a strongly worded dissent here by Judge Singas, joined by Judges Canataro and Garcia. And they say the judge, by deferring it, by saying I'm not going to step 2, the judge was finding it was not unequivocal because of the context, because the defendant was making all these complaints, was saying, I don't like this, I don't like that. He never said specifically, I'm invoking my right to counsel right now, according to the minority opinion here, the dissent here. But once again, the holding in this case is that the defendant being very clear and saying, yes, I want to proceed pro se, at that moment, the judge has a requirement, cannot delay it, cannot say, I'll wait till trial. The judge should have, but did not, immediately go to step 2 of McIntyre and then step 3, and then make a decision. The decision doesn't have to be, I'm giving you you have the right to go pro se, but the judge can't deprive the defendant of steps 2 and 3 and then ultimately a decision on it by delaying that decision. And that's the case of People versus Laquan Lewis. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.